Offer to say this is what I will do, and you shall be heard. May God save the United States of America. Say the Lord and this honorable court.
Well, good morning and welcome to our session of the 5th District Court of Appeals. My name is David Monaco. I'll be presiding this morning. To my right is Richard Orfinger, and to my left is Alan Lawson, who will join me as the panel today. We have 3 civil cases scheduled for presentation today. Each side will receive 20 minutes. If the appellant will let me know how much time they'd like to reserve for rebuttal, I'll be happy to try to remind you of that. That having been said, let's start the first case, Baker and Hostetler versus Linda Sue Swearingen.
Thank you, Your Honors. My name is John Foster. I'm here on behalf of my law firm, Baker and Hostetler, and we'd like to reserve 5 minutes, if we may, for rebuttal. What we're asking this court to do here today is to reverse the trial court's order that determined that it was without jurisdiction to adjudicate our charging lien. And we request
Foster, one
this
of the
court
questions that you could help me with is one of standing. I understand the factual situation here, and I'm wondering what allows you standing to pursue the claim independently. In other words, if the former Mrs. Swearingen, for whatever reason, had decided to abandon her claim for attorney's fees, it seems to me that you have a lien on whatever she is able to secure. But if she chooses to secure nothing or not pursue it at all, I mean, clearly you have a right to sue her for breach of contract and that sort of thing, and we all, I think, probably concede that. My question, though, is your right to independently pursue the claim for fees if she chooses not to for whatever reason.
Well, let me address that in 2 ways, because I think the standing applies to our claim against, our charging lien against the former wife, Ms. Swearingen, as well as our charging lien against the former husband. As the former wife, there were substantial recoveries in this case as a result of the final judgment and marital settlement agreement that was issued. So our charging lien will attach to the recoveries that she received as a result of our efforts. And that provides us with standing in terms of our charging lien as against her. As against him, our standing comes in probably 3 or 4 different respects. First, with regard to her right to recover attorney's fees. There's nothing in the file that indicates that she's released her rights against him. In fact, the record below would reflect that the motion for fees remains pending. And so
but again, my question is, if she just, for whatever reason, decided not to, is it your contention that your firm has an independent right to pursue her former husband for fees if she chose not to?
Absolutely. Under the Irwin versus Marco case and the not be not case, if there's been some reconciliation between the former wife and the former husband, then that brings into play our ability to recover directly against a husband. We also have standing under Section 61.16 to recover fees directly from the husband that the wife may otherwise be entitled to. We have the right under Chapter 7 or Section 61.16 to recover that. And again, the not be not case expressly addressed that issue of standing as against the former husband. In the case where the former attorney for the wife was able to pursue and had standing to pursue the former husband for fees.
Excuse me.
We stand in her shoes with regard to her right to recover the fees because she's not released that right. And without the release, we're entitled to recover it as well. We step in her shoes. Moreover, under the cases such as Miller versus Scobie, to the extent that the arrangement between the former wife and the former husband amounts to some sort of a settlement of which we had no knowledge, and obviously which did not result in any provision for the payment of our attorney's fees, then under that body of law we would have the ability to recover fees against both the former wife and the former husband on a joint and several basis. So we've got standing to recover and to pursue our charging lien against not only the former wife but also the former husband. And what we're asking this court to do is to reverse the trial court's order and to mandate that the trial court adjudicate and enforce our lien. And we ask the court to do that for 3 reasons. First, because the decision is not consistent with this court's prior decision in the Dowda case, as approved by the Supreme Court in 1986 in Daniel Moniz.
Which case was that?
Dowda versus Fields. It's Dowda and Fields versus Cobb, which is at 452 Southern 2nd, 1140, decided by this case in 1984, and expressly approved by the Supreme Court in 1986 in the Daniel Moniz case. The second reason is because the...
Dowda was not a dissolution case, right?
I'm sorry?
Dowda was not a dissolution case.
No, sir. It was a case involving a promissory note, an action on a promissory note.
What was the holding in Dowda?
The holding in that case was that specifically as it relates to the charging lien, that the court obviously had jurisdiction to adjudicate the charging lien. And this is the case where the fee dispute between the lawyer and the client arose during the appeal. And there was no prior notice of a lien filed prior to the final judgment. The final judgment did not reserve the charging lien issue. The fee dispute arose during the course of an appeal, post-judgment, and the court found that the charging lien could be adjudicated in that case. And an interesting thing about that case is this court says, look, the common methodology or method for pursuing charging liens is by summary proceedings in the case in the original action, summary proceedings against the judgment. And the court held, the trial court had a jurisdiction to adjudicate that lien and to impress the judgment with that lien. In essence, instruct the trial court to instruct the clerk to impress the lien by marginal notation on the judgment. Very simple matter. Of course, below the court could have done the same thing by way of order. So the court would have an option of either instructing the clerk to make a marginal notation that would impress the lien against the judgment on the judgment itself, or to issue an order accomplishing the same thing. And so under the Dowda rationale, as approved by the Supreme Court in Daniel Moniz, the court clearly had jurisdiction to adjudicate the lien and enforce the lien and impress the judgment with that lien.
How do you explain Vasquez, Feltman, and Weiland?
Well, two ways. I mean, first, they're distinguishable. And second, they're just plain wrong. Just plain wrong. And we expressed how they're distinguishable in our brief. For instance, the Weiland case.
So you think the second, third, and fourth district, all three are wrong?
Yes, sir. To the extent those cases stand for the proposition that where a fee dispute surfaces during the course of post-judgment litigation of reserved issues, that somehow the trial court loses jurisdiction because a notice to lien wasn't filed before the final judgment, or that the final judgment did not have a reservation of the charging lien issue in it, then they're just plain wrong.
Well, you would agree that those three cases stand for the proposition that in order for the court to adjudicate your charging lien, it would have had to have reserved jurisdiction both to determine fees for the party and to grant the charging lien, correct?
Yes, sir.
That's what they stand for.
That's what they said in the context of those cases, and that's how they're also distinguishable. For instance, in Weiland, like this case, the reservation of the issue in the final judgment was the former wife's fees, and the attorneys, the entitlement of the attorneys, former wife's attorneys, the entitlement of the wife's attorneys to fees. Post-judgment, the issue that arose, the fee dispute, was between the husband and the husband's counsel, and the court said that issue wasn't reserved, and therefore it could not be adjudicated. The distinction is, in this case, the issue being reserved was the wife's entitlement to fees. What that did is create a situation where what the parties and the attorneys knew were a few things. First, that obviously the wife would ultimately have to be responsible for the fees that were incurred on her behalf and rendering services on her behalf. Second, that the husband could be called upon to pay those fees, and that those fees could be called upon to be paid directly to Baker and HOSTETLER under Section 61.16. That's a big difference in this case than in the Weiland case, for instance, where it was the husband seeking to pursue fees against the husband's counsel seeking to pursue a charging lien against the husband, where that issue was not reserved at all. Moreover, they're just plain wrong. As Judge Smith indicated in his order, and it's actually at page 2 of the order, it's in the record at 450. I'm sorry, it's at page 4, record page 452. He determined and indicated that what that creates is your proverbial catch-22. On the facts of this case, and in those situations, a firm like Baker and Hostetler, or attorneys representing in this case the former wife, could never pursue a charging lien.
I guess it's the one part of your argument that I don't follow or understand, and that is that you could not file a notice of charging lien prior to the conflict that you had with your client. It makes no sense to me. I mean, you have a contractual right to pursue a charging lien, and the notice just sort of perfects that right, sort of like a mortgagor who files and records in the public record the mortgage. So why is it that you couldn't file that document earlier?
Well, as the Supreme Court indicated, there's the 4 requirements for the imposition of a lien. The third is that there must be a fee dispute between the attorney and the client in order for that lien.
Well, they didn't use the term fee dispute. I can't remember exactly what their terminology was, but
Well,
your client had not
there must be an attempt by the client to avoid payment of the fee,
and the client
or
in
a
this
dispute
case,
over the fee.
the client in this case hadn't paid you anything, correct?
That's correct.
And years of non-payment. I would think that would be sufficient under that case to allow you to just perfect your right to pursue that charging lien.
Well, as the Shore case indicated, the fact that the fees may be not paid doesn't indicate that there's an actual
But
fee dispute.
that's enforcement. That's enforcement. We're talking about the ability to just perfect the lien.
Well, the line between perfection and enforcement is a very murky and blurred one, Your Honor, as the Littman case indicated and other cases have indicated. What the Supreme Court has said is that when a fee dispute arises, that's when the lien becomes available as a remedy to the lawyer or law firm, and only then. At that point in time...
The Supreme Court said either avoidance of payment or a dispute.
Or a dispute.
You clearly had avoidance of payment here.
No, Your Honor. At the time that the marital settlement agreement
Wait a minute. She didn't pay the $25,000 downstroke that was required by the contract, which contract specifically gave you a right to a charging lien.
That's correct. It did.
Well, if she didn't pay the downstroke of $25,000 and you still went forward, isn't that an avoidance of payment?
But at that point in time, when that marital settlement agreement was executed and the final judgment was entered by the court, at that point in time there was no dispute between Baker and Hostetler and the former wife as to those fees.
Well, the Supreme Court's language says either a dispute or an avoidance of payment.
And there was no avoidance of payment at that point. That did not happen until post-judgment. When the final judgment was entered, the contemplation of the parties and the contemplation of Baker and Hostetler was real simple. That is that the issue of fees, entitlement to the wife, would be reserved in the final judgment.
It was.
Post-judgment, that issue would be litigated and adjudicated by the court or resolved by the parties in post-judgment litigation. The contemplation at that point in time was that either the former husband would be called upon to pay the fees to Baker and Hostetler, perhaps directly under Section 61.16, or to reimburse and indemnify the former wife for that. Or, to the extent that that didn't happen, to the extent that the former husband was not required to pay fees, either directly under 61.16 or otherwise, then the former wife would pay the fees or the balance due under the recovery or through the recoveries obtained by way of final judgment. Let me ask you this.
The fourth requirement, of course, under Sinclair is timely notice, and you're arguing that the other districts that have addressed the issue are wrong in determining when that notice has to be provided in terms of a charging lien. What's your theory as to what the outside limit on notice is?
Well, in a case such as this, where there are issues reserved in the final judgment, and there's post-judgment litigation that is taking place. Clearly, the court has jurisdiction over the case. The court has jurisdiction over the parties. The court has jurisdiction over the attorneys and over the relationship that exists between the attorneys and the lawyers. As long as that litigation remains open and has not terminated, if the fee dispute surfaces during the course of that litigation, that is when the requirement for timely notice surfaces.
And what language in the Dowda case helps you on that point?
The language of the court says a number of things. The court says, first and foremost, that a client should not be allowed to walk away from the judgment without compensating his or her lawyer. That the common method for pursuing a charge and lien is by way of summary proceedings in the original action against the judgment. That in that case, the judgment was a final judgment that was on appeal. The dispute did not occur until during the appellate period.
And there was no
happened,
notice of charging lien filed before final judgment in that case?
No, sir. There's no indication of that whatsoever. The dispute did not surface until the appeal. And the court found that, therefore, the charging lien should be adjudicated, and to the extent the charging lien was found to exist, it should be impressed on the judgment by marginal notation. And as I said, it could also be impressed by order issued by the court. But so under the Dowda rationale, and as proved by the court in Daniel Monet's, the court, in this case, the matter simply remained open. The matter wasn't closed. The litigation had not terminated. And under the rationale of Dowda, therefore, the court had jurisdiction to adjudicate the lien and request that it be impressed on the judgment by way of marginal notation. With regard to the other decisions, in terms of them being wrong, Judge Smith, in the order below, specifically found and indicated that there is a proverbial catch-22. Yes, Your Honor. And what that requires, and what that brings into play is a policy that would compel lawyers to, as a matter of right, file notices of liens in cases, even though there's not a dispute with regard to the fee. What it would require is a policy that would compel lawyers to negotiate on behalf of themselves or their law firms provisions in marital settlement agreements or final judgments for the reservation of charging liens that may be potential in the future, despite the fact that at that point in time there's no dispute over the fee, there's been no avoidance of payment, nothing indicating that the attorney and law firm would not be paid during the course of post-judgment litigation.
You never really answered Judge Monaco's question about avoidance of payment. When the contract says, before we get started, we want $25,000, which was never paid, why didn't that right then give you a right to perfect your lien? Not enforce it necessarily, but perfect it.
Because at that point in time, there was still, the plan was, initially...
It didn't the plan. The contract was clear. Pay us $25,000 to get started. And she didn't do it.
And because we opted not to require that.
Well, and I understand you have that right, but my question is, for purposes of determining what the Supreme Court meant by avoidance of payment, is that an avoidance of payment if she chooses not to comply with contract provision?
No, Your Honor, we never saw that as an avoidance of payment. We opted not to do that. And during the course of litigation, there was reasons for not pursuing interim relief. And bottom line is, at the time that the marital settlement agreement was entered into and the final judgment was issued, there was no dispute with the client. She was not avoiding payment at that point in time. And the
Let me ask you,
plan adopted by the final judgment
does the record
was in
reflect,
place.
I mean, to put it in legal terms, does the record reflect an oral modification of your fee contract? I mean, the contract says pay me $25,000 now and make it, clearly it was not followed. Does the record reflect that there was an oral modification? And if so, what was the new agreement, the oral agreement?
I think the contemplation of the parties is reflected in the final judgment, which was that the issue of fees was to be litigated post-judgment, that the expectation was that the former husband would be called upon to pay all or contribute to those attorney's fees, and that could be done directly under 6116, where Baker and Hostetler would be paid directly by the former husband. And to the extent that did not happen, then the payment would be paid, fees would be paid, or balance would be paid out of the recoveries that the former wife received through that final judgment. And what happened was that plan was derailed. And that is when the dispute surfaced in terms of avoiding the potential for Baker and Hostetler to be paid.
I guess the question specifically was, is there anything in the record that reflects an oral modification?
The final judgment itself.
What's that?
The fact that we didn't pursue a claim at that point in time for $25,000, and the fact that in the final judgment itself, it sets forth precisely what the contemplation of the parties was. And when you talk about the catch-22, that also brings into play the third basis.
Let me interrupt you just for a second. You've got about a minute and a half left in your arguments.
All right, I'll reserve that for the balance.
Good morning, Your Honor. James Campbell for Mr. Swearingen, and Mrs. Swearingen is present too, Your Honor. Judge, I think that what we have here is we have the 2nd District, the 3rd District, the 4th District, the Federal Bankruptcy Court for South Florida, and the Middle District of Florida Federal Court have all adopted the same rule. You file it before the final judgment or you lose your lien. Mr. Foster's arguments here don't make logical sense. He represented Ms. Swearingen for 2 years. He had a $460,000 plus bill. He prepared the marital settlement agreement. He prepared the final judgment. Simply, he could have reserved jurisdiction. For whatever reason, he didn't do that. There has to be finality.
But was there ever a final judgment on fees?
Pardon me?
I mean, fees are treated as a separate matter. For example, in a right to appeal. You don't have a right to appeal until the amount is set. You have to have determination of amount and entitlement. So was there ever a final judgment on the question of fees?
Well, there was a final judgment that reserved on 2 specific issues: Ms. Swearingen's claim against her husband for attorney's fees and entry of a quadro. That's the only reservation, and to enforce the terms of the marital
So there
settlement.
was no final judgment that addressed entitlement or amount of fees?
That's correct.
Okay.
But that was solely Ms. Swearingen's
So
claim.
how can they lose a right to place a lien on something that had not yet been adjudicated?
Well, their right arises. The purpose of the rule, as I read the 6 cases, the purpose of the rule is to have finality to the final judgment.
But you didn't have that anyway because that issue was reserved.
The sole issue of Mr. Swearingen paying Mrs. Swearingen, not his lien. That was not even, the judge had no jurisdiction. Judge Smith admitted he had no jurisdiction over that. That's why he issued the order. All 6 cases say you either file it, and the practical aspect of it is, I would assume that most lawyers in this kind of situation would file something like Judge Lawson said. It's a 1-page document. It's a notice document.
How do you address Dowda?
But I don't think that, I've read Dowda many, many times, and nowhere in there is the issue of notice brought up. There's nothing in the decision that says that there's a notice issue. Neither party raised the notice issue. Neither one of them raised when the lien was filed or how it was to be addressed. It arose after the final judgment during the appeal process, but no one in this decision does it say, was there a notice problem? And
Let me ask you to address the cases that you rely on, and your argument seems to be and rely on a jurisdictional concept, that there's no longer jurisdiction for the trial court to do that,
Correct.
to handle a charging lien. And I'm having a problem, I guess, with that whole position, and I'm trying to understand what aspect of jurisdiction the court did not have. The court did have jurisdiction over the parties still, correct?
for the limited purpose of 2 things: entering a quadro and to adjudicate how much Mr. Swearingen owed Mrs. Swearingen. That's the sole issue. Everything else was resolved. Judgment's final. Parties distribute their assets. And the main problem you have in these cases is when Mr. Swearingen transfers a piece of property or money to Mrs. Swearingen, then he does that somewhat at his peril if this lien is possibly still out there. In a final judgment in a divorce case, when the final judgment is issued, you pay her $100. He pays her the $100. If the lien's out there, he can't pay her the $100 until the lien is resolved. In this case, he pays her the $100. These people come in 6-9 months later and say, oh, now we have a lien that could affect the enforcement of that.
Well, I guess I don't understand that argument either. I mean, he knew at the time that the final judgment was entered that he could be on the hook for the entire attorney's fees amount because the court reserved as to that issue, correct?
On that issue, yes.
Right. So,
but the transfer of other assets to her, he didn't know they had a lien, theoretically.
But that's a dispute between potentially their right to lien proceeds that were payable directly to her and Baker and HOSTETLER. That doesn't relate to your client at all, does it?
Well, I guess that's true, but the problem with the 6 cases, they all say they want finality to this. They want the judge has the jurisdiction ends when the final judgment is entered. If he wants to file a lien, he has a contract. Page 3 of his contract provides clearly he's entitled to a charging lien.
Well, let's talk about, I think we all agree that the final judgment reserved on the entitlement and amount of fees payable by Mr. Swearingen to Mrs. Swearingen.
Correct.
Wouldn't 6116, as a corollary to that, if the court had chosen to do so, allow the court to say that Mr. Swearingen owes Mrs. Swearingen X dollars, whatever the number is, and under 6116, he'll pay that amount directly to Baker and HOSTETLER.
That's true.
So, I mean, it just seems to me that that doesn't create any right other than the court to direct payment, which seems very consistent with the right to award fees.
The difference between a lien, Your Honor, and fees. The lien attaches to everything she gets, theoretically. Everything that Mr. Swearingen has to pay Mrs. Swearingen, there's a lien on.
Well, but you're not representing Mrs. Swearingen.
I understand.
And so the dispute that may exist between Baker and Mrs. Swearingen on the proceeds that she got, that's a different issue. I think what we're here talking about is, can Baker pursue, I mean, I guess in essence, pursue in their own name or irrespective of her cooperation, a claim directly against your client for fees under their lien rights in 6116.
But that didn't raise that issue on appeal here. That's not the issue here. The issue here is their lien alone. The issue of whether or not they can pursue Mr. Swearingen separate and apart without Mrs. Swearingen's permission is not covered in this appeal. I mean, it was addressed in some of the earlier motions filed, but that issue is not the only issue they appealed was Judge Smith's dismissing their right to a lien.
I have a hard time with the idea that they can lose a lien on something that hasn't ever been adjudicated.
But if they don't file it before the final judgment...
How can you lien something that doesn't exist?
Well, it did exist. They owed $460,000.
She potentially owed them. I'm talking about the court never determined whether Mr. Swearingen owed a nickel.
But that's still out there.
I understand, and that's what they're trying to lien. Again, you're not representing.
But that's one thing they're trying to lien. There's four things they're trying to lien. They're trying to lien that right, the house she got, the retirement fund she got, and the monthly payment she gets.
Why do you care about those three things if you don't represent her?
Because we have one of them. Well, we have the right against Mr. Swearingen. They brought us in this. He's trying to lien. He's trying to take her position and enforce the lien as to that right. That's the only reason we're in this case. He's saying, I'm entitled to lien. I can use that lien to go against Mr. Swearingen. But first he has to establish a lien. That's the theory here.
Well, let me ask you, the cases that talk about the reason for this equitable ancillary action talk about the fact that, in part, it would not be fair to allow parties to settle matters without the knowledge of their attorneys and without paying their attorneys' fees, and that would act as an absolute fraud upon the attorney in the court. Right. And it looks like that this is exactly what has happened here. I mean,
Judge, there's nothing in the record to indicate that. Because you have to understand the timeline here. The case was settled in November. The final judgment was in December. This went on until March. There's nothing in there that shows any collusion between Mr. and Ms. Swearingen.
I read somewhere, maybe it was...
No, Mr. Foster put that in his brief. Okay. I think it's inappropriate. It's in his brief. There was no finding of that. There's no testimony. He didn't call any witnesses. There was nothing in there to show collusion. I agree with you. If Mr. and Ms. Swearingen came out and colluded and made a deal, there's a lot of cases on that point, made a deal, of course they would be entitled to it. But that's not the case here. He had the marital settlement. He could have put it in there. The final judgment, he could have put it in there. And he didn't do that. He waited 3 months. You're saying
that under these same facts, if the final judgment's entered reserving the right for the wife to go after the husband for attorney's fees, and the husband and wife then get together and decide we're going to defraud the attorney of their fees, if he probably can't get them from me, the wife, and if I don't cooperate, he can't get them from you, the husband, and we'll have some side deal, that if that was the case, then the firm would be able to file a notice of charging lien and pursue it at that point.
No, they wouldn't be, because they didn't file a lien to start with. If they had the lien, of course
that's
they
what
could.
You just said. Okay.
Well, Judge, filing a lien is a simple.
I mean, it would be it would be unequitable to allow that result, wouldn't it? To allow the parties to get together in some sort of collusive agreement and avoid.
If that happened, we don't have that in this case.
Would it be an inequitable thing? Inequitable?
If they waited 3 months, I don't think it would be. If the lien was out there, I agree with you 100%.
Even if the trial judge had reserved on the issue of the husband's payment of attorney's fees, wife's attorney's fees?
We didn't research that point. That point was never raised anywhere, in below or in the briefs. It was never raised. That's a fairly good question. I'm not prepared to answer that because that wasn't raised here.
Okay.
I mean, I think there was some line of cases about the wife's right. The attorney can't step in the place of the wife without her permission. But I'm not that familiar. I cannot brief that. That wasn't briefed by Mr. Foster. Any further questions?
You had a question, right?
No, I've already answered. You got an answer for me. Thank you very much.
Thank you.
All right, Counselor, you have about a minute and a half left.
Thank you, Your Honor. Another basis is the equitable circumstances surrounding this case. Unequivocally, what the final judgment sets forth is a contemplated plan pursuant to which Baker and Hostetler are expected to receive payment. And it was either going to be from the husband, and perhaps directly under Section 61.16, or from the wife to the extent that the husband was not required to pay all or a portion of the fees. Then the wife would pay those fees, or the balance due and owing, out of the recoveries that she received as a result of our efforts. That was clearly the plan. There was no reason before that marital settlement agreement was executed and that final judgment issued for us to try to predict in the future that we'd have a dispute with regard to that she would attempt to avoid payment of our fees.
Isn't that what banks do every day when they put a mortgage on property? They don't know that they're going to have a dispute with their client, but they secure their repayment by recording a mortgage.
But we're not a bank, Your Honor. We're an attorney. And I think if
No,
we
my
were just
question
willy-nilly
is,
follow...
isn't that what banks do every day? They don't have a dispute. When I go to the bank and borrow money on my house, I expect to repay it. They expect to get repaid. They secure the repayment with a lien on my house. I mean, isn't that what...
Sure
that's just the way the world works.
But that's not the way attorneys should work. Attorneys... First, you don't have the right to claim of lien until a dispute surfaces, until there's an effort to avoid payment or dispute the amount of the fee. Otherwise, you're promoting a policy that allows lawyers, as a matter of course, to file notices of lien, which creates adversity between the lawyer and the client. It indicates adversity.
Counselor, I'm reading Moniz here, and it says, Supreme Court says, Moniz was obligated to notify his clients in some way before the close of the original proceedings that he intended to pursue the charging lien. Simply filing suit gave his former clients insufficient notice. Therefore, no valid charging lien can be imposed on the settlement proceeds in the case of Paul.
Sure. What happened to Moniz, where that attorney went wrong, is he did not do what we did here by pursuing the claim of lien in the original action.
So I
couldn't do it by...
I think the issue boils down to whether simply a notation reserving a right on fees in the original action gives you a right to make further claims on those fees after the entry of the final judgment.
And the issue is whether or not the litigation came to a close when that final judgment that contemplated continued litigation had terminated.
Well, the litigation as to Mrs. Swearingen was closed except for the issue of attorney's fees entitlement from husband, right?
That's correct.
Okay. Thank you.
Thank you. You've exhausted your time.
Thank you, Your Honor.
Actually, we've exhausted your time.